There's no place like home. Hey, this is the next episode of the Faculty Vlog at Pitt Law, in which you're going to hear about the faculty programs that are coming up at this CLE event. We've got 9 different faculty members coming in to talk about research that they've been doing in the past year. You might have heard that my research has been about mental illness and the law, and that's what inspired me to talk about families and housing and mental health issues. I'm going to start my CLE presentation by telling about Social Security disability benefits and some of the ways that can be compromised a bit by family support for housing. I'm going to talk about family caregiver agreements. I'm also going to talk about filial responsibility laws. After I talk about the family issues in housing, I will talk about arranging for accommodations and modifications. This is very important for lawyers to know how to do, but you also need to know what to do about filing housing discrimination claim, a Fair Housing Act action, when a landlord will not make arrangements for accommodations, modifications, or won't honor arrangements that you've negotiated. Next, we're going to talk about eviction. And after eviction, we'll talk about what happens when somebody has left possessions behind and you need to advocate for them to be able to get their possessions back at the end of a housing arrangement. I hope you can come. It's going to be a really interesting day.
I'm Jackie Lipton. I'm a visiting professor at Pitt Law, and I've been here for a couple of years. I teach a variety of intellectual property and commercial law subjects. And in my spare time, I work a lot in the publishing industry. I consult to authors, agents, and editors. And one thing that's become very interesting to me is that in the last year or two, there have been a number of court cases about bad literary agents who have breached their contractual and fiduciary duties to their clients, or who arguably have done that. So my talk for this presentation will be on the extent to which literary agents actually owe contractual and fiduciary duties to their clients and how those duties are breached. The title is, Are Literary Agents Really Fiduciaries? And of course they are. They are agents, they owe fiduciary duties to their clients, but really I'm questioning, how much does that matter? Looking at a bunch of these cases, it seems that judges are very happy to rely on the more familiar law of tort and contracts and not worry so much about fiduciary duties owed by agents to clients. So that will be the focus of my talk, and I hope everyone enjoys it.
Hi, I'm Vivian Curran. I'm a professor of law here, and I teach in the area of comparative and international law. So I'm going to be talking about a statute, federal statute, called the Foreign Sovereign Immunities Act. And this statute explains when a plaintiff can sue a foreign government. And I'm going to be concentrating just on a specific provision of this statute that deals with an exception. That means when, actually the statute, I should preface my remarks by saying that the statute immunizes foreign governments. So the initial step is that foreign governments are not amenable to being sued in the United States courts. However, there are some exceptions, and that's what I'm going to be focusing on. One exception is where foreign governments have expropriated property. But there is also an exception to that exception when foreign governments, even though they have expropriated property, are not amenable to suit in the United States. And that is when they have expropriated property from their own citizens. In that case, we say we leave those foreign governments alone. What they do with their own citizens in their own country is their business, and they can't be sued in the United States for that. We don't interfere with that. That's starting to interfere with other sovereigns' business in their own country. But some of you may know the story of the Klimt paintings that was made into a movie, The Lady in Gold. And this was a woman whose uncle's property, and she was heir to this property. The uncle had died. His very, very valuable painting paintings, among other things, had been expropriated by the Austrian government, both in combination with the Nazi occupation of which the Austrian government was then part, and subsequently to that. She'd been unable to get these paintings back. The Austrian government had refused to return them. And this case went to the United States Supreme Court. And the United States Supreme Court said that the fact that the act, the Foreign Sovereign Immunities Act, had not been enacted at the time of the expropriation was not an issue in terms of retroactive application of the law. And this made a big, big change. So after this case was decided, all sorts of cases involving acts that had happened long before the FISA, FSIA had been enacted started coming to U.S. courts. And as a result of that, many cases involving genocide-related expropriations started coming to U.S. courts. And the courts have been struggling with what to do. And they've been vacillating. And there are some inter-circuit conflicts. And I think that there have been some unfortunate interpretations of international law that have been made by one circuit in particular. And so my talk is going to be about the evolution of the FSIA with respect to expropriations related to genocide.
My name is Pat Chu. I teach at the law school and taught in a lot of different subject areas. One topic that I've had an interest in for some time is how judges make decisions and what affects their decision making. So for this program, I'm going to look at some work that I've done, some empirical work that I've done, that looks at how judges of different gender make decisions in sex discrimination and sexual harassment cases. And then I'm going to compare that to the way arbitrators of different genders make decisions in the same type of cases. And I think I found some really interesting data and some really interesting findings that have application for how judges make decisions, but maybe how we can think about the law a little different.
Hi, I am Professor Hackney, professor at Pitt Law School, and I want to invite you to the faculty CLE. It's happening on February 8th, where you'll get to hear from many of my impressive colleagues. I will be talking about tax-exempt organizations, specifically social welfare organizations. This is my specialty. I worked for the IRS for 5 years in Washington, D.C., regulating the nonprofit sector, which typically we think of as charities. But there's a broad range of organizations. Some of you might have heard about dark money organizations before. These are typically social welfare organizations under the tax code, and they are able to organize as a nonprofit organization and then get tax-exempt status if they promote social welfare. Many of these are groups like the NRA, the ACLU, Crossroads GPS, Hillary Clinton has, I think, Priorities USA. Anyway, I want to look at this sector of groups, which also includes, bizarrely, health insurance and homeowners associations and sports clubs. I want to look at this section and see if there's any rationale for why we give this exemption and whether maybe we should take it away in some aspects. So I'll be talking about these organizations, what they do, and whether they really deserve the exemption that they get. I hope you'll come out on February 8th and check out our faculty CLE. Thanks.